Different types of jurisdiction. There is exclusive jurisdiction, original jurisdiction, appellate jurisdiction, and concurrent jurisdiction. These jurisdictions are relevant, especially when we discuss the jurisdictions of courts. Exclusive jurisdiction is the power of the court to take cognizance of and decide certain cases to the exclusion of any other courts. Examples: MTCs have exclusive jurisdiction over small claims or summary procedure cases. The Court of Appeals has exclusive jurisdiction to annul the RTC judgment. The Regional Trial Court has exclusive jurisdiction over actions incapable of pecuniary estimation. Original jurisdiction. Original jurisdiction is the power of the court to take judicial cognizance of a case instituted for judicial action for the first time under conditions provided by law. Examples: the Regional Trial Court has original jurisdiction over petition for certiorari cases. The Court of Appeals has original jurisdiction over petition for certiorari cases. Also, the Supreme Court has original jurisdiction over petition for certiorari cases. In other words, a petition for certiorari case may be instituted before the Supreme Court or the Court of Appeals or the Regional Trial Court for the first time. Appellate jurisdiction. Appellate jurisdiction is the authority of a court higher in rank to re-examine the final order or judgment of a lower court which tried the case now elevated for judicial review. Examples: the Regional Trial Court has appellate jurisdiction over the MTC judgment and/or final order. How about the Court of Appeals? It has appellate jurisdiction over the RTC judgment and final order. And the Supreme Court has appellate jurisdiction over the CA or RTC judgment or final order. Concurrent jurisdiction. Concurrent jurisdiction or coordinate jurisdiction is that which is exercised by different courts at the same time over the same subject matter and within the same territory, and wherein litigants may in the first instance resort to either court indifferently, that of several different tribunals, each authorized to deal with the same subject matter. And when a proceeding in respect to a certain subject matter can be brought in any one of several courts or several different courts, they are said to have concurrent jurisdiction. Just like the examples given earlier, the Supreme Court, the Court of Appeals, and the RTC have concurrent jurisdiction over a petition for certiorari case. But while courts of concurrent jurisdiction are courts of equal dignity as to matters concurrently cognizable, neither having supervisory power over process from the other, the rule is that the court which first takes cognizance of an action over which it has jurisdiction and power to afford complete relief has the exclusive right to dispose of the controversy without interference from other courts of concurrent jurisdiction in which similar actions are subsequently instituted between the same parties seeking similar remedies and involving the same questions. Such rule is referred to as the principle of exclusive concurrent jurisdiction. Although comity is sometimes a motive for the courts to abide by the priority principle, it is a legal duty of a court to abide by such principle to reduce the possibility of the conflicting exercise of concurrent jurisdiction, especially to reduce the possibility that a case involving the same subject matter and the same parties is simultaneously acted on in more than one court.